Hello, you look like you need some help, but you're in luck because you've reached a dummy's guide to the test of deceptive similarity. If you are considering registering a trademark, it's important to consider the many legal requirements and tests it will be subject to. If your trademark is found not to be substantially identical to another, the courts will then consider if it is deceptively similar to another. According to the Trademarks Act, a trademark is taken to be deceptively similar to another if it so nearly resembles that other trademark that it is likely to deceive or cause confusion. You might be thinking that this sounds like a fairly subjective definition, and you would be right. However, the test to determine deceptive similarity has been helpfully explained in further detail in a number of fundamental cases. The trademarks in question will not be compared side by side. Rather, the test is a comparison between the recollection of an existing trademark in the mind of a person of ordinary intelligence and memory and the impression that such person would get from the applicant trademark. An impression of a trademark can be induced from a number of phonetic, visual, and physical traits. It is for this reason we look to practical examples and cases to gain further insight. Your trademark may be rejected if its name sounds deceptively similar to another. This determination usually relies heavily on the beginning of the words in question. For example, the similarity between burley and barley were deemed to be deceptive by way of phonetic confusion. However, tripcastroid was not deceptively similar to castrol because the similarity originated from the middle of the word rather than the beginning. Additionally, be careful when using invented and uncommon words, as they are more susceptible to tougher scrutiny. For example, the courts refused to register erectico, as it was deceptively similar to another invented word, erector. Your trademark can be rejected if the idea engendered by it is the same as that of another's, regardless of the specific features. For example, while the words dial-in angel and guardian angel were not deceptively similar, the associated logos, which each contained an angel with children, were considered to be deceptive as a result of the idea of the mark and the impressions created by them. Additionally, your trademark will likely be rejected if its name conveys the same idea as that of another. In this example, the trademark name emu was deceptively similar to the idea of the image of the emu on the right. Furthermore, your trademark can be rejected if it causes a reasonable person to wonder whether it might not be the case that the two products come from the same source. In this case, a refrigerator company attempted to trademark the words Southern Cross, but were successfully opposed by Toowoomba Foundry, which owned the mark Southern Cross in respect of well drilling and milking machinery. There was evidence of actual confusion between the marks, particularly because Southern Cross was used for many years for a large range of goods sold at country stores that sold a wide range of products, resulting in consumers showing reasonable doubt as to the connection between the two marks. Additionally, if your trademark represents a group of goods, such as inexpensive products that purchasers view with relatively less care than more expensive or important goods, then it is more likely to be deceptively similar to another. For example, the application of Pearson soaps was opposed by A&E Peers, a detergent brand, on grounds of deceptive similarity. The application was allowed on the basis that, due to the similarity in product type, Pearson soaps would display the brand name and address in visible proximity to the trademark, ensuring no confusion on part of the consumer. So let's recap what we've learned. The test of deceptive similarity is a comparison between the recollection of an existing trademark in the mind of a person of ordinary intelligence and memory, and the impression that such person would get from the trademark you are hoping to register. Before applying, be sure to consider factors such as your trademark's sound, idea, its type of goods, and the possibility of a cause to wonder, all integral facets in proving or disproving a deceptive impression.